For 11 seconds, time stopped inside a federal courtroom in Washington. No coughing, no shuffling papers, no keyboard clicks from the court stenographer. When the judge read a single name aloud, the room froze in a way veteran court watchers say they had never seen before. Even the judge paused, just long enough for everyone present to understand that something irreversible had just happened. Donald Trump did not react the way he usually does. He didn't scoff. He didn't smirk. He didn't whisper to an aide or lean back with theatrical confidence. Instead, he sat perfectly still, staring straight ahead, his face drained of color. Observers described it not as anger, but as shock, the kind that arrives when a threat you thought was behind you suddenly reappears, closer than expected. This was not a dramatic flourish, it was a psychological tell. The hearing itself was routine on paper, a pretrial procedural session, the kind that rarely produces headlines, but at 10:23 a.m. Eastern, the atmosphere changed instantly. When the prosecution informed the court they intended to add a new witness, no one anticipated what came next. Trump's chair creaked audibly as he snapped his head toward his lead attorney. Another lawyer dropped a pen. The silence stretched 8 seconds, 9, 10, 11. Then the defense asked for an emergency recess. That reaction matters more than the name itself, at least for now, because Trump is not new to legal danger. He has been investigated, indicted, impeached, and televised through crisis after crisis. Familiar threats do not stop him cold. Unexpected ones do. When the court resumed, Trump's demeanor never fully returned. The restless movements vanished. The performative confidence evaporated. For the next 40 minutes, he looked distant, withdrawn, as if recalculating a strategy that had just collapsed without warning. This was not about optics. It was about recognition. Whatever name had been read aloud, Trump knew immediately what it meant. He knew what this witness had seen. He knew what conversations they were present for, and he knew before a single word of testimony had been spoken that his legal defense had just entered a far more dangerous phase. Because trials do not turn on spectacle. They turn on witnesses who were in the room, and in that frozen silence, everyone watching understood the same thing. This case was no longer unfolding on Trump's terms. When the judge finally broke the silence, it became clear that the reaction in the room was not confusion, it was recognition. The prosecution was not adding just another witness. They were adding the one person Trump's defense team had assumed was already behind them, a name they believed had lost its power, a chapter they thought was closed. Cassidy Hutchinson. To understand why that name landed like a shockwave, you have to understand who Hutchinson was inside Trump's orbit. She was not a peripheral staffer or a political opportunist looking for relevance. She was the right hand of the White House Chief of Staff, positioned close enough to hear what was never meant to be repeated. She sat in meetings where strategy was discussed before it hardened into public talking points. She listened in on calls with state officials. She observed how decisions were framed internally and how differently they were presented to the public afterward. She was present for conversations that only occur when people believe the room is sealed. That proximity is what makes her dangerous. Trump's legal team reacted instantly because they understood the implications faster than anyone else in the gallery. Hutchinson does not testify about rumors or second-hand accounts. She testifies about moments of knowledge, who said what, when warnings were given, and how those warnings were received. And just as important as who she is what she represents. Trump's defense strategy across multiple cases has relied on a single core claim, that he believed his actions were lawful, that he relied on advice, that he did not know or did not accept that he was crossing legal lines. Hutchinson's presence threatens to collapse that argument entirely. She was in the room when lawyers warned Trump that certain actions were illegal. She witnessed his reaction when those warnings conflicted with what he wanted to do. That is not circumstantial evidence. That is intent. The shock on Trump's face makes sense in that light. This was not a new enemy stepping forward. It was a former insider, someone whose loyalty had once been assumed, now positioned at the center of the prosecution's case. And perhaps most unsettling of all, Trump had no warning. The addition of Hutchinson to the witness list revealed something the defense team had not fully grasped until that moment, that the prosecution had been building this case quietly, methodically, and far longer than anyone on Trump's side believed. This was not a sudden escalation. It was the unveiling of a strategy already in motion. And with that realization, the trial shifted from a battle over narratives to a confrontation with memory, documentation, and testimony that cannot be easily dismissed. What stunned Trump's legal team was not just who appeared on the witness list, but how long she had been there out of sight. For more than 14 months, Cassidy Hutchinson had not simply been a public figure who testified once and moved on. She had been working quietly with federal prosecutors, step by step, inside the machinery of criminal investigation. While Trump's allies assumed the damage from her January 6th testimony had peaked and passed, prosecutors were doing something far more consequential, building around her. This was not casual cooperation. It was sustained, structured, and expansive. Hutchinson testified before multiple grand juries, each focused on a different axis of potential criminal conduct. One examined efforts to obstruct the peaceful transfer of power. Another looked at the handling of classified documents. A third focused on pressure campaigns against state election officials. The same witness returning again and again, describing overlapping events from different legal angles. That is not how prosecutors treat a peripheral witness. That is how they treat a central one. The significance of this cannot be overstated. Grand jury testimony is not about storytelling. It is about precision. Timelines are challenged, details are tested, inconsistencies are pressed until they either collapse or hold. A witness who survives 14 months of that process emerges sharpened, not softened. And Hutchinson did more than talk. As part of her cooperation, she turned over contemporaneous notes, handwritten records she kept while working inside the White House. These were not memoirs reconstructed after the fact. They were documents created in real-time, recording meetings, decisions, and remarks that troubled her even then. Dates, times, participants, direct quotes. Those notes change everything. They allow prosecutors to anchor testimony to physical evidence. They allow jurors to see not just what Hutchinson remembers, but what she wrote when the events were unfolding. Memory can be challenged. Documentation is harder to shake. Perhaps most damaging of all is what Hutchinson represents strategically. She is not tied to a single charge or a single case. She is a through-line witness who can connect conduct across different investigations and show a pattern rather than isolated incidents. That is why the revelation hit so hard in the courtroom. Trump and his lawyers were not facing a surprise witness. They were confronting the realization that a major piece of the prosecution's case had been developing in parallel beyond their field of vision. 14 months of quiet cooperation does not produce a cameo, it produces a cornerstone. And once that becomes clear, the trial is no longer about whether something happened. It becomes about how much the jury is allowed to hear and whether the defense has any credible way left to explain it away. Cassidy Hutchinson is not devastating because of a single statement. She is devastating because she dismantles Trump's defenses layer by layer, leaving very little standing by the time she is finished. There are 4 reasons prosecutors consider her testimony uniquely lethal. First, her credibility. Hutchinson is young, Republican-aligned, and entered the Trump administration as a loyal staffer, not a critic. She had no public profile to build and no political career to launch. In fact, cooperation put her at personal and professional risk. Early on, she tried to limit her exposure, offering narrow answers and seeking legal counsel tied to Trump's orbit. Only later, after pressure mounted, did she sever those ties and decide to tell everything she knew. That arc matters. Juries understand reluctance. They distrust opportunism. Hutchinson looks like someone who resisted until resistance became impossible. Second, criminal intent. Trump's defense strategy has leaned heavily on the claim of belief. He believed the election was stolen, believed he had authority, believed he was acting within the law. Hutchinson can puncture that narrative directly. She was present when Trump's own attorneys told him certain actions would be illegal. She can testify about his response when warned about moments when he chose to proceed anyway, fully aware of the risks. That testimony goes to the heart of criminal liability. It's the difference between recklessness and knowing violation, and it is extraordinarily difficult to explain away. Third, contemporaneous documentation. Hutchinson did not rely on memory alone. She kept detailed notes as part of her role supporting the chief of staff. Those notes, hundreds of pages, corroborate her testimony. They show consistency over time. They anchor her recollections to dates, meetings, and participants. Defense lawyers can challenge a witness's interpretation, but challenging written records created at the time is far harder. Fourth, connective power. Most witnesses illuminate one event. Hutchinson links many. Her testimony touches January 6th, election interference efforts, and the handling of classified materials. She allows prosecutors to present not isolated mistakes, but a pattern of conduct, a sustained willingness to ignore legal boundaries when they conflicted with Trump's personal objectives. This combination is what makes her so dangerous. Remove any one element, and the defense might adapt. Together, they form a structure that is exceptionally difficult to dismantle. That is why Trump didn't react with anger in that courtroom. Anger implies a fight you think you can win. What his face revealed instead was something far more telling. The recognition that someone who knew too much, remembered too well, and documented too carefully was finally stepping into the open. The moment Cassidy Hutchinson appeared on the witness list, Trump's legal team was forced into a dilemma with no clean solution. Every option available to them carries risk, and most of those risks compound rather than cancel each other out. Their first instinct was exclusion. During the emergency recess, lawyers scrambled to argue that Hutchinson's testimony should be kept out entirely. Inadequate notice, privilege conflicts, relevance challenges. The judge rejected that effort quickly, not cautiously, decisively. That ruling alone signaled that the court views Hutchinson as a legitimate, admissible witness, not a sideshow. With exclusion off the table, the defense is left with limitation. They will fight to narrow what Hutchinson can say, invoking executive privilege, attorney-client protections, and hearsay rules. But these arguments are fragile. Privilege does not shield communications made in furtherance of potential crimes, and Hutchinson's presence in meetings does not magically extend confidentiality where it does not legally belong. Even partial victories here may come at a cost. Every privilege fight risks revealing more context, not less. Every motion invites prosecutors to explain on the record why the testimony matters. Then comes the most dangerous option, cross-examination. Attacking Hutchinson aggressively carries obvious peril. She is young, composed, and already known to the public as someone who testified despite pressure. A harsh approach risks alienating jurors, making the defense look punitive rather than persuasive. But a restrained approach may allow her narrative to stand largely unchallenged, especially when backed by notes and corroboration. This is the trap. There is no version of cross-examination that erases her testimony. The defense can try to muddy details, question memory, or suggest interpretation, but they cannot remove her from the room where those conversations happen. Adding to the pressure is the reality that Hutchinson's testimony is not isolated. Prosecutors are expected to use her as a foundation, introducing other witnesses and documents that build outward from what she establishes. Undermine her too much, and the defense risks reinforcing the idea that she is central. Undermine her too little, and her account becomes the spine of the case. Even Trump's own behavior is now constrained. Public attacks on Hutchinson risk accusations of witness intimidation, something prosecutors and the judge will monitor closely. Silence, however, allows her story to dominate the narrative unchallenged. Either path tightens the vice. This is what it looks like when a defense runs out of favorable terrain. Not a sudden collapse, but a narrowing corridor where every step forward makes the walls close in faster. Cassidy Hutchinson's emergence as a central witness does not end with her testimony. It begins a chain reaction, and that may be the most dangerous part for Trump. Inside Washington, reactions have been noticeably restrained. Republican lawmakers who once rushed to defend Trump are suddenly cautious. Statements are vague. Commitments are delayed. Phrases like, "We need to see the evidence and let the process play out," are replacing unconditional loyalty. That shift may seem subtle, but in politics, hesitation is often the first visible crack. Hutchinson presents a problem that partisan spin struggles to neutralize. She is not a Democrat. She is not an outsider. She is a conservative who worked inside the Trump White House and decided at considerable personal cost that she could not keep defending what she witnessed. That narrative is difficult to attack without appearing to defend potential criminal conduct itself. More importantly, her cooperation is already producing secondary effects. Sources indicate that other former officials previously reluctant to engage with prosecutors have begun reassessing their position. The logic is simple. If Hutchinson can testify, survive the backlash, and be taken seriously by the court, others may conclude that protecting themselves legally matters more than preserving loyalty to a man whose future is increasingly uncertain. This is how inner circles collapse, not all at once, but one decision at a time. Trump's own behavior suggests he understands the danger. His reaction in court was not theatrical outrage, it was recognition. And his subsequent silence, uncharacteristic by any standard, speaks volumes. Trump usually attacks immediately when threatened. The fact that he has held back suggests legal counsel has warned him that any public move could worsen his position. That restraint may not last. Trump's instincts tend toward offense, not patience. But every attack carries new risks. Accusations of intimidation, evidence of consciousness of guilt, additional charges. The more visible Hutchinson becomes, the narrower Trump's margin for error grows. What happened when the judge read that name was not just a dramatic moment. It was the public exposure of 14 months of quiet cooperation and the signal that the prosecution's case has entered its most consequential phase. Because the most damaging witnesses are rarely enemies. They are the people who were trusted, who were present, and who finally decided they could no longer look away. And once that decision is made, the fallout does not stop with one testimony. It spreads through legal strategy, political alliances, and personal calculations until the entire structure begins to shift.